Good morning. I want to extend a warm welcome to my dear friend, Professor Dr. Anup Surendranath. I will reflect on my own association with Professor Surendranath. You have heard of Professor Madhav Menon. He's a doyen of the legal education. And a few years back, he organized a faculty development program for law teachers at Lloyd Law College and asked me to deliver a talk on what universities can do. And then Professor Sashikala Gurpur from Symbiosis Law School Dean was there. Professor Purvi Pokhriyal was there. And so on many teachers. I spoke to them about the best practices. And when it came to research, I picked up the NLU Delhi's research on abolition of death penalty, where they conducted interviews with death row prisoners across the country, documented, and then highlighted the shortcomings in the criminal justice system and also advocated for reform. And it was kind of a best practice, which I haven't seen a similar project which involved extensive research, and then based on it, a series of important recommendations were made. I was there for the launch of that report, and some of my students later on joined him, and one of them is a first batch of the Jindal Global Law School by name Peter John. And Peter John worked on the mental health of the death row convicts, and he used to share the findings, and he used to share the issues surrounding the abolition of death penalty. And I also had the opportunity to attend the World Congress on Abolition of Death Penalty at Norway, and where I was invited as a speaker to speak on the role of national human rights commissions in the abolition of death penalty. And I had an opportunity to listen to Dr. Anup on that occasion as well. And there were many, actually, while I was working with the Jindal Global Law School, we tried hard, but without success, to get him to join the Jindal Global Law School. And me and Professor Raj met him a number of occasions. And I keep following him on Twitter and other social media handles, and keep silently admiring the excellent work that is being done by the Dr. Anup Surendranath and his views on various issues. We could not have had a better person than him at the launch of the Center for Criminal Justice Studies at our law school. We already have a few research centers. There is a Center for Human Rights Studies, Center for Health Law headed by Professor Arpita. And then we also have Center for Disability Studies, Professor Magana is there. And there are Center for Community Engagement. There are a few other centers. And today we are launching Center for Criminal Justice Studies, which is led by both Shantanu and Isha. And I compliment them for starting this center. And today there is a need for extensive research. When you look at the various wings of the criminal justice system, there are a lot of problems you find. A few days back, the Chief Justice of India lamented on the Tariq pe Tariq. And then a couple of weeks back, the Nithadi accused were let off. And of course, the Nithadi incident where children were killed and shook the conscience of the nation. And again, that reflects on the shoddy investigation done by police, and the lack of evidence. The whole case fell through. And if you look at the prisons again, there are many problems, like the under trial prisoners, the insanitary conditions. I remember my visit to Ranchi prison, where along with the former Chief Justice, Justice Verma, and as a chair of the NHRC, he was an inspection visit to Ranchi. In a room like this, some 600 people were held, and when we asked them to lie down, they could not lie down with their legs stretched, and they were taking turns in sleeping. And so is toilet prisoner ratio, sanitation. And I, as a part of the inspecting team, I went and I saw a place where life sentence prisoners were there, and there was one person who was trying to attract our attention, who wanted to talk to us, and he was calling, and his voice still reverberates in my ears, and he has been ignored by the society. They're now confined in a solitary cell, and so there are many issues which plague. And then recently there have been reforms to criminal law after the Nirbhaya incident, and also in the recent. So we are very glad that we have Professor Dr. Anup Surendranath with us to explain the proposed criminal law bills and also tell us more about it. Thank you. With these words, once again, I welcome Professor Surendranath.
Thank you so much, sir. Now, without further ado, I invite Professor Anup to share his reflections on the proposed criminal law bills.
Great. Good morning, everyone, and thanks for having me here. It's absolutely fantastic to come back to a place with Professor Murthy and Shantanu, both of whom I know quite well. And then Professor Murthy has laid out our interaction earlier, and Shantanu was also worked on his LLM dissertation with me, a very well done LLM dissertation, which is also published thereafter. So it's great, and congratulations to Isha and you for starting something so important. And may I dare say, what will be a difficult journey, right? And it's not easy starting these things. It's well, I guess the starting of it might be easy, but sustaining it and creating the impact, especially in a field like criminal justice, for many reasons that even Professor Murthy has said, is a challenge, right? So I'm here to talk to you about the criminal law amendment bills, the 3 criminal law amendment bills. I'm told the audience is largely first-year students and first-year LLM students, and I have taken 3 of their permission to do it more like a class. So the teacher in me, so I'm not going to lecture you as much as I'm interested in hearing what you have to say, and sort of maybe challenging you and pushing you a bit to sort of question some of your assumptions and maybe sort of learn from you as much as you might learn from me. And that's how any effective teaching and learning should happen. Look, where I come from, my perspective on criminal law and criminal justice administration is influenced by my work at Project 39A, and I have seen the realities of how the criminal justice system work and over the last 10, 11 years, and it's very much influenced by that, right? And of how our prisons are, how our law operates, and the way we approach and look at crime, and the manner in which we seek to regulate crime, and also the manner in which we deal with people who commit crimes, right? I try and avoid as much as I can the use of the word criminal. Much better to use the word people who commit crimes, because people who commit crimes, there are many things to their lives and personalities other than the fact that they have just committed crimes, right? So might be our language tends to convey a certain politics and a certain violence, and therefore just to be careful about how we articulate these things, right? So that's a broad, whatever I say, you can view it from this perspective, and I just wanted to lay it on the table that I come from a certain perspective, and you should know that in light of what I'm going to say today, right? About the bills as such, whatever we have to say is there here, right? We have produced 2 substantive analysis documents of the changes. So what we are certainly not going to go through today is do a clause by clause reading of what the 3 bills say, how is it different from the IPC, and I'll do some amount of that, but that is not towards tracking the changes and telling you assessing those changes. All of that is there in these two documents. It's on our website, and I'd encourage you to read it. It's a very detailed assessment of the changes. How does it differ? What are the consequences? What are the possibilities? What are the dangers across the Bharatiya Nyaya Sanhita, which seeks to replace the IPC, and the Bharatiya Nagrik Suraksha Sanhita. I still need to keep referring to those titles. I guess at some point it'll come naturally. And also the Bharatiya Saksha Bill, which seeks to replace Indian Evidence Act, right? So in terms of if you're interested in that sort of what are the precise changes, what does it mean, how is it different, all of that's there in these two documents, and I will invoke some of it, as I said. But for a more detailed and thorough understanding, please read these documents, and I'm just not going to take you through what is already written here, right? But I want to, since we are interested in a critical assessment of the bills, I'm going to precisely do that and see what these bills seek to do they achieve it, and how do they go about achieving it, right? Can I get a sense of, just very quickly before we start off, I don't expect many of you to have thoroughly gone through the bill and the draft and the provisions, but can I just quickly get a sense of what have you heard about these bills, and anything, it doesn't have to be some big coherent narrative. What are some of the points you've heard about these three bills? If you can just put up your hands and encourage students to speak. It's absolutely, there are no right answers, right? Everybody is learning. And it'll take months and months, and if not years, for all of us to get familiar with the absolute nitty-gritty details. So, interest in hearing, what have you heard through newspapers, conversations, blogs, anything, classroom discussions? What have you heard about these bills? When you speak, just introduce yourselves. Give me your name, and if you're a student or a faculty or a researcher, yeah, please.
This is Professor Meghna Sharma, and I'm an assistant professor
Right.
at the university. The one thing that I consistently hear about these bills is that they are more victim-oriented than the previous, than the current criminal law.
Right. Okay. Victim-oriented approach. Okay. Then, when I say okay, it doesn't mean I agree, but yes, that is a point. Yeah. Anything else that you've heard? Anything at all? I'm sure you've heard of certain key phrases in relation to these bills. I'd like to hear that from you. Yeah. Anything at all? Any important changes that you've heard? Go on, don't.
I think there's more integration of technology.
Right.
Say,
Yeah.
e-filing and all.
Right. More technology, audiovisual use in investigations. Yes. Okay. Anything else?
Actually, interestingly, just last Friday, Professor J.S. Vajpayee he gave an interview and he commented this bill, and I because you were coming, so I saved his remark. And he
Yeah.
said that,
We might not be on the same page, but yeah, sure.
the major concerns that this bill tends to address is pendency and overcrowding
Yeah.
of jails, low conviction rate,
Right.
delayed investigation, and certain procedural complexities.
Yeah. But yeah. We can assess all of those things, but yes. See, one word you would have heard, one phrase that's thrown about is that it is criminal law reform, right? And I want to interrogate that claim quite a bit of what is it reforming, right? And what should reform of criminal law look like, right? So that's one thing I want to look at. The second phrase you might have heard is decolonization. Right? That it seeks to decolonize Indian criminal. a bit from its predecessor colonial legislations, right? So there is the idea of decolonization, right? So these are the first two things I want to sort of interrogate and say, what are we trying to do, right? So when I say decolonization, right, of criminal law, there's a need to understand the colonial context of these laws, right? There is quite a bit of legal history writing by academics like Radhika Singha, who you should read her book called Despotism of the Law of Criminal Law in Early Colonial India, that it is difficult to think of, or even if you read that colonial literature around criminal law, to think that criminal law was just doing one thing, right? That criminal law's purpose in colonial administration was just one thing. That you might think that, the common narrative might be that it is a tool of control, right? There is a tool for the colonial government to control and organize its native subjects, right? And sort of it's a subject and government relationship. It is not citizens because you're in a colonial setup. It is about the subjects to colonial government, that it is about control, right? But that might not, and that certainly does not capture the dynamic of what the colonial government was doing with criminal law. That certainly is a purpose, right? Is to bring in that kind of, for very administrative efficiency reasons, it seeks to bring in through criminal law and codification a certain coherence, a systemic coherence through this codification. That's certainly one thing, right? And then is about controlling its subjects. It's about that value of how do we control the native population. And also there is a larger expansion of certain values from English common law that they're trying to export and subject the colonial population to. And you will remember, and important to remember, that the provisions of the Indian Penal Code are just not Indian things. It was exported to quite a few of the other British colonies. And if you see Singapore, Malaysia, some of the best writing on the Indian Penal Code emanates from Malaysia and Singapore and on the Indian Evidence Act. And you should certainly read those books because the provisions are the same. There's some minor changes, but the kind of case, it's very enriching to see our jurisprudence, the kind of cases we've had to decide, along with the kind of factual situations that have arisen in Singapore and Malaysia, and how they have addressed with the same provision, how they look at, let's say, something like the insanity defense or murder or culpable homicide. It's again, for a different talk perhaps, right? So so there is this colonial context that the colonial government is not doing this thing just in India, but it's also doing in other colonial countries, colonized countries. But I think the point and the complexity I want to introduce is that there is a certain project that Macaulay is interested in through the IPC, right? And that project is connected to the larger utilitarian project of Jeremy Bentham, right? You have to understand that there's a certain a larger intellectual movement in Britain at that time saying that we need to codify laws, and there is a certain purpose to codification of laws, right? That you put it all down. So the idea was not just let's collect the laws and just print them, right? There is an idea that you need clear universal laws. There is a certain utilitarian ideological commitment behind codification, which is quite distinct from the purposes of colonial politics. There is that, you can't separate the two entirely, but there are two elements to this. And then there is the interaction between the need for colonial power and the utilitarian politics of it, right? Of saying that, there is great benefit in having these clear, precise, and universal laws. And very interestingly, the sort of Benthamites, and I'm not getting into the complexities of how Macaulay had certain important differences with what Bentham was saying, but I'm not getting into all of that. But you have to understand, why is a colonial government trying to bring in a law or a legal measure that then applies to everyone equally? Right? It's not like they were saying, it's not like apartheid South Africa, right? Where you have a different legal system, you have different legal provisions, right? And therefore, this is not as simple as bad colonizer, good colonial subject kind of very clear sort of distinction. It is not that, right? It is part of colonial policy. Again, I'm not here trying to make a case that somehow there was some benevolence behind all of this, but it is far more complex than what we make it out to be. That just because when we get into this conversation of decolonization, we don't understand what the context in which Macaulay was operating and what is the value for the rule of law, right? And I'll come to another further that the rule of law, saying that we will make the Indian Evidence Act, we will have a procedural code, we will have the Indian Penal Code and apply it to everyone in the colony, right, is an important thing to appreciate, right, alongside the politics of it. Now, what happens, what Macaulay might have intended with the IPC, right? And he felt, and of course there is a idea that this sort of enlightened elite can do this better, rather than, and then there is also that kind of racist interpretation saying that the people of the colony cannot do this on their own, so it's better for a sort of enlightened elite to do this and impose it on them, and that's the better thing to do. But even Macaulay's intention that we must have these clear, comprehensive, common rules does not play out in its administration, right? It does not play out in its administration, and I urge all of you to read Elizabeth Kolsky's work on I think it's called White Justice. I forget the exact title. I use it when I teach evidence law. It's a great documentation of what Macaulay was intending just didn't play out in colonial India, because in its application and in its procedural implementation, there is a great distinction between what the law was and what was happening to the law, because there was very, how do I say this? It was a very skewed implementation where the natives bore the brunt of the law, and in different ways, exceptions were drawn to have more lenient treatment to the white population. Right? And she documents that, especially in the context of the Indian Evidence Act, and says how the sort of treatment of scientific evidence, right? And and the idea that scientific evidence is subject to lesser scrutiny, right, under the Indian Evidence Act, and the prioritization of scientific evidence, and if you look at, and we can look at how that plays out in the Indian Evidence Act and its interaction with the CRPC. She has a great story on the spleen defense, right, and she builds it over a set of cases. What is the spleen defense? And what I'm trying to say, and what I'm trying to get you to appreciate, is how one common set of laws can then, in its implementation, have very disparate implementation, right? It is a very unfair, discriminatory implementation. And the spleen defense, what I'm going to tell you about the spleen defense is an example of that, right? Now, what is a spleen defense, right? So she contrasts the cases when there are white defendants and native defendants in murder cases, right? When the colonial courts are looking at murder cases, she contrasts what happens to murder cases when there are white defendants and native defendants, right? And she says that whenever there would be cases where there were white defendants and people would, some sort of physical action of pushing or hitting or whatever, inflicting blows would lead to the death, and where the victim was a native, right, it would lead to very different implementation of criminal law, because what had happened was that there was a scientific discourse developed that natives died not as a result of the physical action of the person pushing or hitting or inflicting blows, that natives were dying because they had a weak spleen. That Indians had a weak spleen. Therefore, it was a result of the weak spleen and the rupturing of the spleen that caused the death, and not the hit, the actions, the actus reus, if you may please. It is not the action of the white defendant that causes the death. And this was backed by scientific discourse, right? It is not somebody's opinion. It is scientific evidence used to be given that, okay, Indians have a weak spleen, and therefore the spleen ruptured, and that rupturing. So it's a racist evidence argument that, it is our weak spleens that caused our deaths and not. So, and that's why I'm saying that what the supposed neutrality of the law does not play out in its implementation in colonial India, right? So having set this network, I mean, and you also read Mitra Sharafi on blood analysis and serology, and how this entire sphere of forensic evidence and its colonial history sort of served this kind of dynamic that I'm talking about, right? And it's a fascinating history, and I hope you have at some point the opportunity to consider it. Okay, so now having said all of this, what are we trying to decolonize? What are we trying to decolonize? When we say we are decolonizing, what are we decolonizing? What are we interested in decolonizing? The manner in which?
Administration of the law is done.
Okay, interesting that you say that it is the manner in which the law is implemented. Okay, but let me just push you a little bit on that. Sorry, your name? Kajal, right? Do you teach here? Yeah, okay. So, Kajal, my question to you would be, why not the fact, what we want to decolonize is the fact that the British made the law. We just don't like that. We just don't like the fact that, I mean, of course, the constitutional lawyers here would say that that's not entirely true, how this continues in independent India has a certain constitutional process, and therefore it's not like, nobody applied their mind to it in independent India, right? But would you think that the mere fact that this was made in colonial times is reason to decolonize? Would you think that is the content of decolonization? That this was made by a colonial government. In its origins, it's colonial government. Anybody? Look, I don't have some great answers to all of this. My job is only because I'm sitting here, I get to pose the questions, right? If you were sitting here, you would pose the questions, that's all. So I have no enlightened extra knowledge over any of you or most of you, right? But that's an important question to ask, right?
Serve the interests of the welfare state or the socialist state.
Yeah.
Not the colonial rule.
Or the colonial, right?
The offenses, the punishments,
right,
and everything.
Correct. So we could take that approach, right? We could say we want to revisit how these offenses are being defined, What are the punishments, right? Is it that one of the things was, what is the role for property in the Indian Penal Code? Does the colonial state have a certain interest in approaching property offences or offences against the state in a certain manner in the Indian Penal Code, which a post-colonial state might not or should not be interested in the manner in which it is drafted in the IPC, right? If you look at property offences and if you look at offences against the state, it's quite prominent in the Indian Penal Code, right? So as I was saying, is it about that the decolonization is about revisiting the definition and the content of the offences, right? Is it that? Is it the approach to criminal law, right, that we need to decolonize, right? Whatever it is, I think we all might feel a little silly if it is just about changing the label, right? We all might feel that if it's just about change of the label, it is a little silly that you've just put another sticker on top of it. Instead of the Indian Penal Code, you've called it the Bharatiya Nyaya Sanhita and you've changed the label. Unfortunately, it is just that. It is just that. I'll come to why the parts it is not that is more problematic. And why do I say that, right? We put out 3 documents, right, in addition to these substantive analysis, and that those 3 documents were the first things we put out. What did we do in those? We said, let's compare the text of these 3 bills to the text of, let's say, the Bharatiya Nyaya Sanhita to the IPC. Yes, there is a lot of changing of order, numbering, title, all of that. But about 80 to 85% of the text is the same as the IPC. Right? Same. They might have changed the numbers and the ordering and all of that. Right? So in the document we put out, we said all the text that has been retained is colored in yellow. All the absolutely new text is in green, right? And the same text is in red. The slight modification text is in yellow, and the absolutely new are in green, right? You will see that document. It is a sea of red, right? Therefore, and that's true of all these 3 bills, right? They retain a lot, and this is not some exaggerated claim I'm making. They retain quite a bit of the provisions, right? In that sense, Macaulay has had the last laugh, right? Macaulay has had the last laugh, right? Because even in an exercise meant to decolonize, you are not able to escape what he drafted, right? And it asks a larger, broader question to us, right? Singapore or Malaysia or African countries that had the...
Can I request those who are online to mute themselves? Sachin, can you mute all of them?
You want to see?
We'll come to the Q&A at the end.
Yeah.
Go ahead.
Yeah. So, so the question is, if at all we are interested in decolonization, this is not decolonization. We haven't really discussed, we haven't had that public conversation as a society and as a country. What does it mean to decolonize? I might provoke you to think that what decolonization means is to fundamentally alter the relationship between the state and citizen. Right? That is a core element of decolonization. Right? And that we are not interested and we have not redefined that relationship between the state and the citizen, where in a colonized existence, the state is interested in controlling its citizens, right? It has a deep anxiety that its own people are, that for the colonial state, there is a deep anxiety that the people that they are controlling or governing pose great threat to their existence. And I offer to you that colonial anxiety continues into the independent Indian state. Right? And that plays out, and you can look at the various laws and the manner in which that system of control, that framework where the state is interested in controlling its citizens. You might ask, what is so wrong with it? Right? But that is for, again, depends on whether Shantanu and Isha call me again. Right? If there is anything wrong with it, I'm assuming that is not what we want our governments to do, that governments need to have better things to do than think of their own people as the enemy. And it can't be a framework of control. Right? And that the relationship between the citizen and the state has to be something deeper, something more meaningful, and something more equal. Right? That the state is holding the power of the people in trust. The job of the state is not to control its people. It cannot view its own people as the enemy. Right? And I would think that any conversation on decolonization has to start with this fundamental dynamic. Right? And these bills certainly don't do that. It even does not do the good things that Macaulay was trying to do with these laws, of which is very clear, universal. It is very evident to everybody what is the behavior that is being criminalized. So if you look at the definitions of terrorism, organized crime, prevention of false information, or even the provision for replacing sedition. Yes, sedition as a word is gone, but if you look at clause 150 of the BNS, you will see it's a much wider, more problematic provision. Right? So it's not like sedition is shunted out. Yes, the word sedition might be now taken out of the BNS, but if you look at clause 150, it is a more dangerous clause than. So what is happening? You are using vaguer and vaguer criminal laws, where it is not clear to citizens like you and me or persons living in this country as to what exactly is being criminalized. So you have taken the special laws, what might be what might exist in these organized crime legislations of the different states. Different states have organized crime legislation. There's a Guchkoka or the M-Koka. I think Karnataka also has an organized crime legislation. Right? You have now taken those state legislations and you made them offenses in the central legislation. You have changed definitions, you have widened definitions, you have diluted protections that exist in those, right? So what you've ended up doing is that you have created vaguer, wider, broader offenses with more power for the state. Because you haven't imported those protections, but you have imported the framework. And particularly in terrorism and organized crime and this prevention of false information, please go through our substantive analysis brief on how these very, very problematic things are being done, right? So the point I'm trying to make is it is difficult to justify these bills as some sort of meaningful exercise in decolonization, right? That is the first point I want to leave you with. And now about reform. When I used to teach legal methods to first years, I taught it for about 4 years. I started teaching constitutional law, and then I decided the cynicism of third years was too much for me, and then I'd rather deal with the energy and enthusiasm of first semester students, right? It took me 4 years to realize the problem with that approach, but I taught legal methods for 4 years to fresh first year students. They would come in with all bubbling energy, wanting to change the world, and by the time they got to third year, they'd be like, why did I even come here, right? So anyway, that's more failure for us as a system than I suppose. But anyway, the point of that segue was on the question of reform. The first thing I would make them read was the story called The New Constitution by Sadat Hasan Manto. Right? It's a short story, and I realized after the first 2 years of doing legal methods that starting with this reading called the Spelunkian Explorers was the worst thing to do, because first, what, do you start with Spelunkian Explorers? Sorry. You did, right? No. I also did. I also did, right? Because I thought the reason why I started with Spelunkian Explorers in the first 2 years, sorry for the segue into legal methods, but was that it is a great, profound expression of the distinction between law and justice, right? And one would assume that it's engaging the students, and it does. I think at a certain stage, it is very engaging. You can use it in legal methods, you can use it in jurisprudence, you can use it in interpretation of statutes, whatever. But I realized that students struggle to even understand that kind of reading, because I think in schools we are just not taught how to read, right? And reading that kind of material. So so after 2 years of starting with this materials like this, I switched to just starting with non-legal material. I would not make them read any law for the first 2 weeks. And instead, I would focus on making them read non-legal materials and try and develop skills required to read legal materials. So I would give them long form journalism pieces or whatever to say, okay, tell me what is the point in this, right? So it develops the skill rather than the, even I thought Spelunkian Expo was the coolest thing to give in the first week of law school, and it took me 2 years to realize perhaps it's not. So anyway, the point and connected to the question of reform in Manto's new constitution, and of course I was only reading the translation from Urdu. So Manto's story is about this Tongawala called Mangu, right? It's about the 1935 Government of India Act, which is the sort of new constitution he talks about, and which has considerable impact on the Indian constitution later. So this is a 1935 Government of India Act, and Mangu is of the story that, Mangu hates this white client of his, right? Who's taken his, who's hired his Tonga services, and he's really abused. He got into a fight with Mangu, and he abuses him and beats him up. And Mangu is really, he wants revenge, right? He's like, he wants justice more than revenge. He wants justice. Whether two are the same, we leave it for another day. So he wants justice, but then suddenly he hears that, some of these, he hears from Indian people who are sitting in his Tonga that a new constitution, Naya Samvidhan, is about to come, right? And Mangu's hopes for justice rise day by day, and he then slowly hears about when this new constitution is going to come into effect, right? And Mangu is like, yes, our time is coming, right? There is a new dawn where, we will have people like him will have rights and they will be equals, right? So suddenly the day has come, and Mangu is all where he has heard that from today the new constitution is in force. Mangu is like, yes, it's my time has come, and he gets out, and suddenly everything seems the same, right? Nothing seems to have changed, and Mangu is wondering, what's happening? Why hasn't, why everything, the streets look the same, the surroundings look the same? What's wondering? And he's like, but the new constitution is coming. And then he meets this white guy again. And he says, and he starts getting into a fight with him, right? And he says, now you cannot do what you did to me earlier and all of that. And they start getting into a fight, right? And they get into a scuffle. And then, sure enough, the ending of the story is that the cops come and treat Mangu in the very same way that Mangu was treated the first time he got into a fight with, and he's taken away screaming, but the new constitution is here. The Naya Samvidhan is here, and he's dragged away with him screaming that, right? The point of narrating this story, right, and in a far less effective manner than Sadat Hasan Manto, please do read the story, right, is that, and the reason why I give it to first years, is to make them realize that laws change very little, right? Laws change very little of the reality, right? And because I think students come into law school, and I think we perpetuate that sense of the grandeur of the law, right? That we think that the law can solve, the law is enough to solve social problems, right? And that narrative, we believe in the grandeur of law as law students, as law teachers, as law practitioners, as judges. We believe in the grandeur of the law, and we are not sufficiently skeptical about the limited things the law can achieve, right? That for the law to achieve its ends, it needs a lot of other things to work around it. The law by itself can achieve very little, right? And therefore, this whole idea that we can legislate our way out of social problems, that we just need to make a law and suddenly child labor will disappear, or dowry will disappear, or deaths in sort of dowry harassment deaths will disappear. We have countless instances before us where legislations cannot cure social problems, right? By themselves. I'm not making a case that the law has no role, but the law often assumes a far greater role for itself than it should, right? Or now, so having said that rather skeptical view of the law, can I just hear from all of you in terms of what are we trying to reform? What are we trying to reform in the criminal justice system? Or what do we want criminal law to do? What do we want criminal law to do?
Reformation
Reformation.
of the convicted.
Straight. I would say the law is interested in putting fear in you. Is it?
Yeah.
What's your name? Sorry.
Mayur.
Mayur. You're in which year are you? LLM first year. Right. LM only year. Yeah. What about, yes, sorry.
So, I'm Roshan, I teach School of Law. In response to your question, it makes me more confused because one of the things that I was working on investigating is with AI and criminal justice. So one of the questions that we are left with is the problem of if you have to work with policing and AI, are you trying to prevent crime or increase arrests? So
Right.
I think the bigger challenge here with criminal law is, are we preventing crime or are we increasing arrests?
Correct.
From the experience that you've seen, how would you?
Yeah.
I
No.
think this will give us an answer.
Absolutely. So, Roshan, that is the exact conundrum, right? That is, so when we view criminal law, right? So when we legislate against, let's say, child labor, or let's say dowry or cruelty, right? Under in the IPC, right? What are we interested in? Are we interested in preventing cruelty, or are we interested in punishing those who inflict cruelty on people, on women? What are we interested in? What you might say both, right? But according to you, what are we interested in? What should we be interested in? So if you have 100 rupees to invest, right? Let's say you have 100 rupees to invest on the issue of cruelty, or let's say on the issue of sexual violence. Would you invest more on prevention, or would you invest more on punishment? Or are you saying punishment will lead to prevention? Okay, go on. So what's your name? Muhammad Salman. Which year? BA? BLLB? BBLLB. Right. So Salman, you're saying punishment will lead to prevention. Just tell me more. How?
Like if we implement harsh punishment, it might cause a deterrent factor, which creates a sense of fear among the citizen, that they fear the punishment and they tend to move away from the
Right. So people know that if I inflict cruelty, look at those people who got arrested and punished. I will also get punished or arrested. I don't want to get punished and arrested and punished. And therefore I better not inflict cruelty on my wife, whatever, right? Clear? But why does it still then happen?
In our country, the punishment is like
is not, you could say punishment is not high enough, or you could say punishment is not given routinely enough. Which one is it?
Like one is the punishment is not that high enough.
Right.
Second is people get away with the crime easily.
Right. People get away, right? So,
But there are a lot of loopholes in law that can be abused by the schools
Hmm.
to get away from being punished.
from being punished. So for all of you, it is that if we implement our punishment system better, either with higher punishment or certainly with higher punishment and better implementation, plugging loopholes, people can't get away so easily, right? Who gets away so easily?
One will good that okay.
One with good. So that means one with the money, right? The one with the money who gets away. The other person is lying in Parapanagrahara, right? So the point I'm trying to make is, you're right. That is the common way of thinking about criminal law, right? It's a dominant way of thinking about criminal law, that if we punish more, people will regulate themselves and not, right? And I think child sexual abuse is also a good example of it, right? Very often things that we really shocks us, right? But anybody who disagrees with that view? Yeah.
Yeah, so my name is Abhijit, I'm also BBA as a first year. I disagree with the view because as I was doing a bit of research on the death penalty and why it should be abolished, I found out that in countries that follow the common laws, such as Bangladesh, who also impose the death penalty for such crimes, crime rate has only gone up. The death penalty hasn't served to be a deterrent and hasn't really done anything to attack the root cause, which is prevention. Like, how do we prevent the crime?
Yeah.
Instead of instigating higher levels of punishment.
Punishment, right. So it's not like India's murder rates are dropping, right? It's not like our rates of sexual violence are dropping, and there's quite a bit of literature around that. Is it that it's happening more? Is it that reporting is happening more? That's why we are seeing more numbers. But whatever it is. But what I want you to think about is that there are certain limitations of thinking about saying that just because I criminalize something, people will not do it. Starting from your most common traffic offenses, helmet, red light, insurance, we all know we are hedging our bets, right? I know where the cops stand, right? I know in Delhi where I drive, I know on my regular path, I know where there are the speed cameras. When I'm reaching there, I will go at 40. Moment I'm past that, right? So the point is this, and that is only complicated when we come to issues of cruelty against women, sexual violence, that fear can only regulate behavior so much, right? We cannot solve social problems through fear, right? Just a second, right? We have to think about why is crime produced in society, right? Why is crime produced in society? What is the social, economic, cultural, and political dynamics that result in the production of crime? Right? And the punishment model seems to think of crime and criminality as a bad apples problem, right? What do I mean by that? It seems to have the analogy that to prevent crimes or whatever, the manner in which we can deal with criminality in society is to think of it that if I have a tray of 100 apples, I know that 40 apples are bad. I just need to throw the 40 apples. I just need to identify these 40 apples and throw it out. And then we have a good, happy society. That we are not doing a good enough job as of now of identifying the 40 bad apples. Right? That is our problem. This view that we were discussing, and that is the dominant view, this view of viewing criminal law and social problems views that as a bad apples problem, that we are not doing a good enough job of identifying those 40 bad apples. Right? But my provocation to you is that is the wrong analogy. The more relevant analogy to think of is that the tree itself is poisoned. That the apple tree is itself poisoned. It will produce good apples and bad apples continuously. And just picking out and throwing the bad apples is not going to stop the prevention of crime. Because it is the tree, it is the very root that is producing the crime. And that we need to understand and move away from this understanding of crime as a free will phenomenon, as a very thinking of crime and criminality as some sort of individual free will phenomenon as compared to crime as a social phenomenon. Right? And that fundamental shift is crucial in understanding criminal law reform. And if we are really interested in criminal law reform, we will think about crime from that deeper sense of perspective that, the master narrative of crime, and I urge you to read work by Craig Haney on this, who's a psychologist, and psychology has made great strides in understanding how people end up committing crimes, right? It's not the wiring is wrong in somebody's head and therefore that person is a criminal, right? And therefore criminals are more prone to commit crimes. And they have shown as to how the production of crime is a much larger interaction of the individual with their psychosocial, biological factors. Right? It's the individual's interaction with the psychological factors, with their biological factors, with their environmental factors in terms of their family, friends, support structures, lack of support structures, cultural factors, economic factors. So it is a complex phenomenon of how crime gets produced, of the individual interacting with his or her surroundings and their own psychological and biological makeup. It's a complex mix of all of this. There is no point pretending that it is just about bad people, which is the predominant assumption of our criminal justice system. And that is why we aim to think of reforms in the manner in which it is envisaged in these three bills. Because if you are truly interested in preventing crime, right? Thank you so much. Thank you. If you are truly interested in preventing crime, we have to do the tougher, less attractive. It cannot be a 2-minute Maggie solution. And doing this kind of thing, trying that we will make more laws, more and more laws, we will criminalize more, we will broaden definitions of crime, we will give more power to the state to arrest, right? All of that is the 2-minute Maggie solution. And we all know Maggie is bad for health. We know it, but we still love it. We know it and we still love it, right? And that is a love-hate relationship. We have with criminal law as well. We know criminal law cannot solve our problems, but we want more and more and more of it. and our politicians are happy to give it to us. Like Nestle, our politicians are happy to give it to us because it's an easier thing to do for them also. Oh, Nirbhaya happened, Hathras happened, right? What do you want? You want more punishment? Here. India now has non-homicidal death penalty. By amending the POCSO and the IPC, you have non-homicidal death penalty. What does that mean? That you can now get the death penalty even if you have not caused loss of life. For rape alone, for rape without causing death, you can now get the death penalty. It's non-homicidal. The offense is non-homicidal, right? What happens to this notion of proportionality of punishment? Right? This is no way to defend child rape or sexual. It would be ridiculous on my part to do that. That's not what I'm arguing for. But if I were to ask you, what produces sexual violence in society? Why is sexual violence against women and children so rampant in our society? What would your answer be? Why? Let's openly discuss it. Why is there such rampant sexual violence in our society?
So first thing can be
Name.
Myself Akil from BA Delhi.
Right. Okay.
So first thing can be patriarchy or the man who consider themselves dominant over women. So
Therefore,
that can be a notion because as I have seen an interview of the Nirbhaya rapist, so he was like women shouldn't go out alone and they shouldn't be moving out at.
yeah, I wish he had better lawyers who told him to shut the hell up a few months before execution. Right? Anyway, that's a different point, right?
He was telling that it's the fault of women that they go out.
So is that view held only by the Nirbhaya convict? No, I'm asking.
No, like
I'm not saying you're saying that, but you're saying that is a view that is commonly held.
like most of the interview, if you see of the rapists, the most of them ideology will be the same. Like
Only of rapists or people who are not rapists also?
Like most of them, those are we can say uneducated because they are like men are dominant over women. So
Only uneducated.
like most commonly.
Most commonly, right? So Akhil's point is that there seems to be a education-linked approach to this that that men think that they are dominant over women, and what does this dominance then translate into? That they can then physically assault women? No.
Like they see that they are superior in every aspect, like
Right.
mentally, physically, everything.
Okay. Sorry, you spoke already, right?
Yeah.
Okay. So we'll just wait, see if anybody else. See, these are things on which you have to have a view, right? It's not, I'm not asking you to, whether you've done a reading or whether you've read the bills or whatever. I'm sure you think about these things, and it's only about drawing you out, right? So yes, would certainly want to hear women speak on this. Yeah, please go ahead.
The way they are brought up, basically in Indian households, we see it like if a boy does anything, okay, it's okay. The parents are like, they will grow on their own, don't worry.
Yeah.
So that is one notion, but anything that happens, the child in the budding years, it's always the mindset develops at the.
And it starts from our societal preference for the male child. It starts from there, right? You hear of all these thing of, you've heard about how certain scanning technologies are banned, right? Under what legislation? Any idea?
Conception.
Yeah. Under the PNDT, right? You hear of all these practices of how if the doctor writes the prescription in red, it means girl child. Because you need to do the scans. The law only prohibits that you can't communicate it, right? Because for other health reasons, the scan needs to be done. So if the doctor writes, like you hear in many states, that if the doctor writes the prescription a certain color, it means girl. If it's in another color, so the doctor has not communicated in any manner. The law is in compliance with the law, but everybody knows this is the code. This is the cheat code, right? So it starts from there. Then it starts from, preference for who gets what kinds of resources in families. And I'm not saying any of this happens in our societies, right? Then in education, who is sent to which school, right? Who gets the better opportunity? In whom is there more investment, right? From nutrition to education to all sorts of things. And then it starts getting even murkier, right? Guys are allowed to go outside, go to some other city, go to whichever institution they want. There are women-friendly courses, right? Oh, why do you want to go to mechanical engineering? Right? Criminal defense lawyering though is absolute no-no, right? Then it's a men, because men have more rights to pursue their careers, and it is the job of the woman to supply the household labor, right? And that is why you see while there is even in law firms or in the judiciary, at the bottom the gender ratio is okay, even in law firms or the bar or judiciary. As you go towards the top, there is significant dropping out, right? Also true of NLU vice chancellors, or other vice chancellors, but anyway, right? No, but the point I'm trying to make on the patriarchy point is that it is not just men who rape. It is also in our daily lives that these notions about what women are and what they should wear, when they can go out, can they be seen drinking, can they be seen smoking, all of that, there are very gendered notions, right? And that those are all deep social problems. And if we start thinking about how we want to solve them, it is not a matter of a 2-minute Maggie solution, right? And all of these social dynamics have very significant impact on crime, criminality, and people who commit crimes, right? These social attitudes. And I'm just talking of gender. We could talk of caste, we could talk of sexuality, disability, all of that, right? So the point I'm trying to make is, what are you trying to reform cannot just be a simple thing of I need to amend the law, make things more criminal, make more punishment. That can't be your approach to criminal law reform. It is a rather shallow approach to criminal law reform, and my submission is that these are just that. They don't do anything else. They don't even look at the capacity of other criminal justice institutions to deliver criminal justice. Be it the police, be it the bar, be it legal aid institutions, be it prisons. You have to view, even if you're looking only at criminal law, you have to look at criminal law within a criminal justice ecosystem. And that criminal justice ecosystem is horribly weak. And Sir has extensive experience with that. And when you think of criminal law reform, to think of it divorced from reform of criminal justice institutions, their capacities and their practices is just meaningless, because you are just going to put these amendments into a broken criminal justice system. And it is a broken criminal justice system. It is broken for the victim and it is broken for the accused. Why is it broken for the victim? Nobody wants to ever have to deal with a police station. God forbid I have to go and put some complaint that something has happened to me, or much worse if you're a woman or a Dalit, right? No, it is not a good experience for victims in our criminal justice system. But neither is it a good experience for the accused. Torture is rampant. Manipulation and planting of evidence is rampant. Prosecutorial misconduct is rampant. So at both ends of the criminal justice spectrum, there is a crisis. There is no point pretending that we can do justice to victims by taking away more and more rights of the accused. Both are problems, both require their own solutions, and there is no point pitting the accused against victims, right? So just to keep that in mind, that a larger issue of reform must look at the more deeper socio-cultural and economic and political causation of crime, right? And also even within criminal justice administration, that unless you reform criminal justice institutions around it, you are really going to struggle to do any meaningful reform. One last view on the very specific process adopted on these reforms. My own university was very significantly involved in this, right? And it is to their credit that, and I must say it, that they have had no issues with me taking a position against them, right? And it says something that I have consistently written, that the procedure adopted to do these reforms is deeply flawed and anti-democratic, right? You cannot have done a consultation during a pandemic. The consultation for this was done during the pandemic, right? There is no information on how the committee drafted these questionnaires. How did they identify these are the issues to look at in the questionnaires? How did they process the responses that they got to those questions? What is the methodology that they used? Right? We don't know any of that. Right? Why were only predominantly lawyers consulted? Right? And what is this thing of, oh, we will put out a questionnaire and you write in responses? What did you do with the responses? Right? Did you read them? How have they influenced the process? None of that. From purely a methodology perspective, the very idea of what you put into those questionnaires inviting responses is a political choice. And we have no idea why that was so. We have no idea how the report of that committee has been used by the government in coming up with these bills. The Home Minister said that, so many universities, law schools, but nobody knows who are these universities and all these people who have been consulted, right? So there is a very serious, on an issue that has a ramification on so many of us in so many different ways. The process that has been to undertake this massive exercise to replace these three fundamental laws suffers from a serious democratic deficit, right? And I think the contents are reflective of that. I really don't want to comment on the very poor drafting exercise being done in these bills, but that's just a minor point. Just the quality of drafting and the inconsistencies is something that one was surprised by, but that's just a minor point at the end in light of all of these things. So I will leave you with these, I've overshot my time, but I will leave you with these thoughts and sort of critical perspectives through which to look at these criminal law amendments as you start engaging with them more deeply, as you might well have to sooner than you think, right? So do keep these critical perspectives in mind. And as I said, for the provisions themselves and their analysis, please do read what we have put out. It's a rather detailed document and analysis. I'm sure you'll benefit from reading that and understanding that. But do use certain perspectives to look at it, right? Yeah. Thank you so much.
Thank you so much for your valuable insights, sir. Now the floor is open for questions, and for the audience who's joined via Zoom, please type in your questions.
Unmute them. And, I have one question.
Yeah, sure.
Putting on a devil's advocate argument, like the founding of our republic was, surrounded by bloodshed, communal violence, etc. Then we also witnessed so many wars, and so the state has a right to protect itself.
Right.
So of course, colonial masters were replaced by our own government.
Yeah.
So when you see that there are external threats, etc., national security challenges, and then there are fratricidal wars, and then the idea of India as a nation is not fully evolved, and there are sub-regional and other fissiparous tendencies. So why shouldn't the state, through the criminal law reform, secure itself? Like, when you talk about offences like sedition, offences against the state, what prevents the government? Because it has to exist. Self-preservation is a major thing. So why shouldn't it protect itself through the mechanism of law, particularly things like treason and unorganized crime, and or even proscribing terrorism and other things.
Right.
That's one. And second question is about NLU Delhi. Like when the Home Ministry tried to reform this, I understand that NLU Delhi served as a secretariat, or so wasn't there a democratic consultation within NLU Delhi? Could you have not put your critique within the NLU Delhi, or was it a limited engagement? Or was the draft given by NLU Delhi not fully taken into account by the? You haven't seen the because while I was in Jindal, we received a letter from the Home Minister saying that in case you have suggestions, please pass it on. And there was a letter from Professor Krishna Deva Rao, and before that Professor Ranbir Singh as well. And so there was some consultation, but again, it could have been a better consultation. And so who picked the issues? And even now, there's a lot of opacity about how these issues were picked, etc., and how the draft came about. So wasn't there consultations organized by NLU Delhi within the NLU Delhi, or in the larger legal fraternity before the report was finalized? And I just wanted to know the process adopted by NLU Delhi as well. Sorry for these two questions.
So thank you, Professor Murthy, for that. On the question of can't the state protect itself, I think there's one thing to say that the state is doing much of these reforms is not of the kind that attacks are offenses that attack the very existence of the state or the integrity of the state, right? So yes, the sedition replacement may be viewed in that manner, right? Which is about addressing that, you're doing some sort of, it's addressing activities. I don't know if somebody can just look up, if you can just read out clause 150, the kind of clause 150 of the BNS, you will see that yes, what you're saying, that the sovereignty of the state, the existence of the state are things that they're trying to protect themselves from. But we need to see as what has happened to sedition in independent India, right? And that gives us a good indication. What did you prosecute under sedition? What you prosecuted were absolutely ridiculous things.
Environmental activism.
Environmental activism. If somebody has celebrated Pakistan's victory in a cricket match, somebody has worn Pakistan cricket team jersey, right? The news journalists, right, reporting on certain things. So if you see the pattern, and Article 14, the news website, Article 14 has a sedition database, which shows you what has sedition been used for. It is not for things that any reasonable person would say threatens the existence of the Indian state. It is out and out used as an abuse of police power, right? And therefore that is my point. The state projects a certain reason, and yes, there we might agree that should the state protect itself against its own the threats to its own existence? Yes, but we know that these provisions don't get used for those kind of things, right? And therefore that, sorry, do you have, 150? Yeah. Now look at 150, right? Whoever purposely or knowingly, by words, either spoken or written, right? Or by signs, or by visible representation, or by electronic communication, or by use of financial means, or otherwise, excites or attempts to excite secession or armed rebellion or subversive activities, or encourages feelings of separatist activities, or endangers sovereignty or unity of integrity of India, or indulges in whatever, right? Now, a provision like this is so broad, so vague, that it's really, we have to understand the realities of how these provisions get used. We can't be limited by the discussion on, is the aim of such a provision, does it look legitimate to us or not? Yes, it does look legitimate, right? But is that for what it is used? or or is it too broad, or is the burden on the state to arrest or prosecute in these matters sufficiently limited? It is not. So when it is not coupled with those kind of limitations on arrest and prosecution, these become extremely draconian provisions. So while might not quibble with the underlying sentiment that nobody would say that, oh, we don't need to protect the unity and integrity and sovereignty of India. My point would be, is this the way to do it, right? That would be my point. On the NLU Delhi thing, I think there were some limited consultations after during the drafting of the report. I was not part of it. Was I asked to be part of this? I suppose initially there was some conversation, but I think I made it clear that this can't be the manner in which one consults, and suddenly you are trying to undo 1.5 centuries of a law in about 6 months. That's not how you do it, right? You can't. That's I think we should have the humility to accept that these kinds of massive changes require a certain kind of democratic deliberation. And for me, that was what was most problematic, that we were trying to change the very fundamental fabric of criminal law in such a shallow manner, right? Yeah. Thank you. Yes, sorry.
My question is about the sociological argument that is advanced in terms of reforming criminal law. And I totally agree that deterrence has, or the approach to deterrence theory has completely failed in preventing crime. I have read the report, that penalty report that Project 39A has released, and in terms of, for my research, in terms of reading as well, I have conclusively proved that deterrence has not been able to, let's say, reduce the number of murder. But then, and I totally agree with it, and totally agree with the sociological causes that results in crime. But then I find myself a little confused and a little in a weird position, because sometimes there's also a psychological argument that human being is ultimately the product of their own action. Two human beings in the same socio-economic condition might not turn out to be the same.
Absolutely.
So ultimately, the actions that one chooses to indulge in. And if this is not to say for the very vague and vague definitions of sedition, or the very unclear crime that this new bill has, but generally as an approach to criminal law. Ultimately, the purpose is to ensure safety of human beings. And so my question maybe is, do you think deterrence is completely unqualified if we think about its utility for in terms of the purpose that the criminal law seeks to achieve?
Yeah, no, thank you for that question. Look, I'm not making an argument that individual punishment for actions is not required, right? But that's not my argument. My argument is that we tend to rely only on that, right? Yeah. And there is another conversation to be had on the extent of the punishment, on whether it's proportionate, disproportionate, all of that. So that's one thing on that. But on the question, on the fundamental point that you raised, if whether two people in similar socioeconomic circumstances, it's not necessary that they will do the same thing. Absolutely, I agree with you. And I think it's an important question you asked, because I'm not making the argument that we don't have control over our actions, right? That somehow everything is predetermined, right? That it is deterministic in that sense, that everything that I'm about to do after I step out of here is already predetermined because of various factors influencing my life. That's not my point. I'm saying it is we underappreciate the complexity of how individual free will interacts with our biopsychosocial factors. That we don't appreciate in criminal law. Criminal law proceeds on the assumption that it is only about pure individual autonomy. I get to decide. My free will is like 24 karat gold. It's pure. Everything I decide is a product of individual will. That is what I fundamentally disagree with, right? It is not. I think the manner, even when we think we're exercising a choice, our choice is shaped and influenced by many things in our lives. It might be about my psychology, my biology, my family, my culture, what I watch on television, what I read. It is influenced by many things. And therefore, it is not that it is not just structural, but neither is it just individualistic. And we need to understand that complex interaction. And I don't think criminal law does a good job, not just in India, anywhere, that criminal law does a good job of how that complex interaction should influence criminalization and questions of punishment. Yeah.
Sir,
Yes.
sir, you made a reference about how the tree would be poisonous, and it's not just about removing the rotten apples.
Yes.
And it's just that the tree is only poisonous.
Yeah.
So I really stopped thinking about it, and it gave a correlation to how the society is
Absolutely.
poisonous.
Yes, that was the right.
That was the thing. So my question to you would be that how do you propose to make the tree unpoisonous?
Yeah, exactly, right. What is the
And also secondly,
sort of probably plant a new tree.
and also secondly, we have had a vast exercise of analyzing the new laws.
Yeah.
And my thing is that my opinion is that we can't really do anything about it because our voices would go unheard of, and the government would not be willing to
Yeah.
step back on that
Right.
aspect.
So sorry, what's your
point
name?
is that it's not vast enough, and the democratic consultation is not
Yeah.
deep enough. And
Yeah.
Yes.
What's your name? Sorry.
Mayur.
Mayur. So Mayur, on the larger point of, what is the point of discussing all this? None of this will happen, right? Especially as young people, right? As young adults, I would caution against, and I keep telling my students, it cannot be that me as your teacher is more optimistic than you as the student, right? In the sense that they may not read it. They may not even read what we've put out, right? And but that should not stop us from saying that, I don't know if any of you remember what happened in Hyderabad. There was this rape and murder case, right, where the woman was burned, and then these 4 accused were shot dead by the police when they took them to the crime scene to reconstruct the crime scene, and the police claimed that they were seeking to run away from there, and they shot down all 4 of them, right? I'll tell you why I'm telling this. And then there was a great celebration. They showered flowers on him and milk also, and said, this is what we need. This is justice, right? And everybody was like, yeah, this is justice, right? Right? And what is the point of going to court? Some fools like this Project 39A will then defend these fellows. They will argue that there is not enough evidence. They will argue that no, you cannot give death sentence.
It'll take 20, 30.
It'll get 20. They will keep, this is why, finish it off. Yes. Tomorrow, if you are arrested for eating beef, do you want the police to handle you like that? If the police arrest you for reading a book they don't like you reading on Naxalism, do you want the police to deal with you? We have these reactions because we feel we will never be victims of those actions. That our loved ones, our friends, our families will never be touched by these excesses of police action. Therefore, we say, kill them. Good. All rapists must be dealt with like this. The point I'm trying to say is, when you say, what can I do? What you can do is, A, not react like that when you see these things, or when you talk about crimes and people who commit crimes. Karnataka has this great fascination with this guy called B.A. Umesh. I don't know how many of you know. There have been films about him, right? Right? Umesh Reddy. Right? And do go and look it up, right? Now, the kind of voyeuristic manner in which we view have committed horrible crimes, right? It has taken 10 years to make us see some point, and it has been continuous telling of stories of our clients, right? What has happened and what they did, why they did it, what has happened to them in prison. So now she thinks
I could not convince my father.
So exactly, right? So it's very difficult, right? But that's what we can do, right? So today when she talks to her colleagues in her school, she has a slightly, I'm not saying she's some great abolitionist of the death penalty now, but at least it's a more tempered conversation. It's more thoughtful, right? Okay, maybe this is also there. But that's how societies evolve. We do what we can. When we are in positions of influence, we try and influence. When we are not in positions of influence, we can only influence what is around us, right? So it depends on whether you think that is worth it or not. But I certainly do think that, as young adults, you should find value in that. That's the only hope for the future, right?
Sir, what about the rotten tree?
Yeah, I see. Either we find a way to cure why it is getting poisoned, or we find another tree and we find another tree. I don't want to say cut down the tree because that seems quite violent. Cut down the tree and kill the tree. We go against whatever I've been saying so far. So I should think about this tree analogy a little more before I use it again. Thank you. Yeah. Yes.
Over a period of time, we have had good judgments of the Supreme Court and some High Court with respect to mandatory registration of FIR and with respect to handcuffs, limited use of handcuffs. And so, how are we actually reforming anything, or are we actually in the garb of reform? We are actually removing whatever protections we had. Yeah,
I think it'd be a great project for the center to do. First up, to say, what is the interaction of the new provisions with existing Supreme Court case law, and especially on the things like handcuffing and all of that. I think it is going back to what the Supreme Court has already said, right? And I think that might be a good thing that can be done quickly. It doesn't require any field work, right? To just say, how does this push us back from where the Supreme Court has already got us? And particularly even on victims' rights, I think that is right. I don't think the bills go as far as what the Supreme Court has already gone. And therefore, it's a certain rolling back of what the Supreme Court is saying, even on forensic evidence. So I think it would be a very valuable thing to do that comparison of how does this sit with existing progressive Supreme Court case law on certain aspects. So, sir, yeah.
Sir, my question is, we have seen that your whole point was that the law reforms is not sufficient. It should do something else. So, what the government can do other than the legal reforms, so that we can make the criminal system better?
Yeah. So, look, one is we can look at this purely in terms of reforming criminal justice institutions. Now, if you say police reforms, right? What do we need in police reforms, right? A, we don't have enough number of police people. Two, what are the practices that the police adopt? Why do they adopt those? Like torture is the most common investigation method. We don't have a modernized police force because, and beyond a point, you look at why does torture persist in India so much and why is such a part of our investigation is because governments don't want an independent police force. And we've been talking of police reform since colonial times. The police is not independent. The governments like keeping police under their control. They don't have sufficient access to resources, to independent, to sort of scientific investigation techniques, right? So what are the kind of practices that they have? So much of police force goes into bandobast duty and VIP security and all of that. So these are all very serious structural issues which we can cure. Or our courts, what is happening in our criminal courts? Do we have enough judges? Do we have enough well-trained lawyers to assist judges in criminal cases, both in prosecution and defense, right? So what is the docket of the court in criminal cases? How long does it take? How do we adjudicate bail? What is the state of bail law in this country, right? Bail law in this country is extremely anti-poor, right? It is anti-poor. It is anti-poor because we have a very property and money-based bail system, right? So there are even with criminal justice institutions, prisons, it's not like people like Professor Murthy have been saying this for years together. All of that is there. All of the research recommendations, all of that is there. Nobody seems to care, right? So that is just about criminal justice institutions. Not even talking of broader social reform on what are the kind of things we can do to reduce sexual violence in society. That is not my area of expertise, right? But those kind of sociological interventions, economic interventions, we have to think of those interventions rather than just thinking in terms of, but that the people who do that work and know that are the ones that we should be listening to, and not just saying we'll convene one session of parliament and amend our criminal law and hope that sexual violence will come down, right? Yeah. Sorry.
So, my name is Prashant and I teach legal methods. And Professor, there's a lot for me to take away also how I'll approach legal methods from now on. But this issue about decoloniality and decolonization and the posturing which is done by the government with respect to attempting reforms in various areas. So criminal law is one area where this attempt has been done. But now we are hearing that it is also being
constitution.
It is getting to the sphere of the constitutional law realm also.
Yeah.
And this is something which you mentioned in your talk, that there's a lot of hard work that needs to be done before you even start thinking about something like this. Can't be a two-minute Maggie solution. And because in this room there are a lot of first-year law students. If you could talk a little bit about how would this process look like in an idealized setting. I mean, I'm hoping there's still a little bit of idealism left in all of us. If, let's say, the government is approaching this project of decolonization with the right intentions and has the, how would that process look like, and how should we be vigilant and be participating in such kind of a process?
Yeah. So I would, thanks for the question, Prashant. I would say that there are a lot of colonial continuities in our criminal justice as we today, right? And some of the practices that exist in our criminal justice system, how it is the poor and the marginalized that occupy such a large proportion of our prisons. Why is that so? Why is it that the poorest and the marginalized are the most victimized by our criminal law, right? What are our bail practices? What are our trial practices? And I think that's why I said that how have we defined, is the Indian state okay inflicting this kind of suffering on its own people? And I think the starting point is that. Are we willing to change that? Right? And then we can move on to what should be the definition. What is the decolonial definition of murder? Is for me a bridge that is very, very far away. Today I am interested in why is there so much torture in our criminal justice institutions? Why is it so difficult for a woman to go and file a cruelty complaint? Those are the questions, and I think those are colonial continuities. It comes from a certain feeling that it is okay to ignore this kind of suffering, not take this kind of suffering seriously. Because if a state had a very different relationship and imagination of its relationship with its people, it would address these things on a priority basis, right? And the fact that we are willing to not invest and do what is required to resolve this shows a certain kind of indifference for me, which is a very different kind of individual and citizen relationship, state and citizen relationship. So I would think there in that manner, right? What does this indifference communicate to us? I think for me it communicates a certain where it's okay to accept this kind of suffering, right? For me then, therefore, how should property offences be defined in the Indian Penal Code are all issues far ahead of us, right? And amendments are not So anything on that?
When you talk about continuity, there are many vestiges of colonial practices. Courts have said, don't use my lord, your lordship and all that. But still, that is very difficult to kick it out of our systems.
Even that is difficult to kick it out.
Yeah, actually, there are a number of courts across the country, even the Supreme Court are saying just say sir or your honor or something. But still, people are not able to shift because of the long historical.
So when something as simple as that, we are finding difficult. I think when Justice Narasimha just did. Said this. So we're struggling even to say, okay, we will not call you my lord and we'll call you sir. You can only imagine when we're talking of police and courts and everything more entrenched, how difficult it's going to be. And therefore, I'm saying that is the effort that is required. This is not the effort that is required to now say I will have some great definition of organized crime and therefore that will solve all problems. This seems a little silly, to be honest.
This is a very important project though, but it requires more deliberation so that across the board there is a sensitization and participation.
Was there a question?
Actually, what do you feel about the justice systems? Actually, even in the Nirbhaya rape case where there was a minor. So I feel that there should be some kind of equal kind of punishments even for the minors, as he was a minor and he it's just a form of the justice.
He just got 3 years.
Yes.
Right.
It's just a form of an injustice.
I disagree, right? With that, in the sense that I mean, not getting into the specifics of this. How has the juvenile justice law changed, right? The juvenile justice law now has this concept of a preliminary assessment, right? Where if you are between the ages of 16 to 18, I think, right? If you're between the ages of 16 to 18, there will be a preliminary assessment to be done to see whether you will be tried as an adult, right? Which is not there then, right? So they have to do a preliminary assessment. So you're below 18, you're between 16 to 18, there are certain kinds of offenses that are there for heinous offenses. The law is supposed, the courts are supposed to make a preliminary assessment of whether you should be tried as an adult. The law says, yes, you can be tried as an adult if the preliminary assessment says you should be, but you cannot be given the death sentence. Every other punishment is okay. So you can even sentence a 16-year-old to life imprisonment, right? And I think it is shocking that we think our children must be subject to this criminal justice system, right? You might say, oh, they are not even children if they believe that they can rape and murder. A 16-year-old can rape and murder a woman in the manner that they did. How can you even call that person a child? You might say, how can you even call that person a human being? It takes all longer conversations of why, right? But if you, and it is amazing what has happened to this preliminary assessment system. Right? How would you assess if a 16-year-old should be tried as an adult? Would you just look at the offense? The law has come up with some great formulation. Did they understand the true nature of what they were doing? How are you going to assess that? How do you distinguish one 16-year-old person who has committed rape and murder from another 16-year-old person who has committed rape and murder on this ground? Whether they understood the true nature of what they were doing. How are you going to establish it? And therefore you are sending more and more children into the adult criminal justice system. Is that the society we want to be, that at 16, I am going to be told to you, and under these amendments, they are saying you can be kept in prison for the rest of your natural life? That a 16-year-old does something like that. Isn't there some element of social failure? I'm not saying, that individual has no responsibility, or that individual should not be punished for 3 years, 5 years, 7 years, whatever it is. But can't we be honest to ourselves that if our children are committing offenses like this, that there is some element that we have also failed. That instead of being in school, this is what is being done. What of our social structures, our families, our schools, our various other institutions that deal with children? What has happened? And now everybody wants to say, oh, give harsher punishments for children. So again, I go back to the same theme that, instead of saying why are our children doing committing these kinds of offenses, I would ask, are we getting our engagement with children all wrong, right? Or that we're not investing enough in it, right? Instead of saying if we punish them more, somehow they will not do all of this, right? And since I'd have to deal with 17, 18-year-olds, the kind of, and just to the tangent on it, the nature and the frequency of instances of sexual harassment and the kind of sexual harassment, even in campuses like ours, where, yes, students come from well-to-do families, they all have a certain background, they've gone to very good schools, right? But their kind of attitude towards their female peers is shocking. What they think they can do and how they do it. We really need to worry about. So I'm not saying that there isn't the worry that why are these things happening, but I'm saying the solution to it might not be what you're suggesting, right? And the kind of violence is just, I don't know, it's a very deep social problem, right? I'm not denying that there is that kind of violence. There is, absolutely on board with that, but I don't think more punishment is going to solve it.
The Jindal, there was a gang rape of a student by a fellow. It went up to the Supreme Court. Then one student was given 20 years, and then 2 students are serving 7 years.
And the kind of facts in that case.
The kind
why?
Of
and for me, the question was how are they dealing with each other in that manner?
Yeah.
Rather than anger and saying, oh, put this fellow behind prison for, right?
The society, the larger society is to be blamed. And
what is it? Is it that what they're watching online or
we have produced?
What we produced? It's the apple tree.
Yeah.